So there's $450,000 of gain from the time the person bought it, and if you put your child on the deed, when you die, it's theirs. But when they sell it, their basis is $50,000. So they have to pay taxes on $450,000 of income. If they inherit that house from mom or dad through a will or through probate administration without a will or trust, then if it's worth $500 and when mom or dad dies, and we go through a little bit of effort, through that process, then when they sell it for $500, they owe zero taxes because the value, they get a step up in the value, a step up in the basis. So, and as you guys could imagine, we see that all the time. And once you do that, you can't unring the bell once that's been done. Once a child is on a deed, you can't then take them off of the deed, and unfortunately. So, real estate joint ownership, great tool with husbands and wives or business partners maybe, but not parents and children typically, unless it's a very specialized, specific situation. For example, I'm helping my son buy a house, and I'm helping him with the down payment, and I'm helping him co-sign on the loan. Then I would want to be a co-owner on the deed, right? Because I've got skin in the game. But that's very specialized, and there's not much equity to begin with, so it's not a big deal at that point. There are times when we do use that, but it's not typically in the context of an older person that wants to make it easy for their children when they die. So real estate, joint ownership, life estate. Life estates are pretty good tools, but you have to understand kind of the nuances and how that works. But a life estate is where you have a property and you want to convey it to somebody, but you want to reserve the right to live in that property till you die. And we do see that a lot. Unfortunately, we still have the problem with the capital gains and the appreciation, because when you make a transfer to somebody with a life estate, you actually do transfer that interest to that person. You just reserve the right to live in it till you die. So it can be an effective tool, but don't really do that a whole lot, to be honest with you. Administration is the third way that we transfer real estate at somebody's death. That's either through a will or through a probate administration where they died without a will. Because of the step up in basis, that's a great tool. And use that a whole lot. Also, transfer of real estate in a trust is a very, very good way to transfer real estate. And we're going to talk about the benefits of wills, the negatives of wills, and the same with trust here in a few minutes if we have time.
How do you protect yourself with the ever-changing laws that we have? I know that today you've got certain parameters around certain accounts where you can hand off things within a certain limit, and then the limits change.
Mm-hmm.
How do you protect it? Because a lot of times we're going to one of these understandings and go to a lawyer and have it drawn up, and that fits great with the laws like we are right now. You kind of go to sleep, and maybe 10 years later, 20 years later, and all of a sudden what you had set up, the laws have changed, and all of a sudden it's not good. How do you protect yourself against that?
Well, a more sophisticated operation than I run. Maybe his operation's better than mine, but my operation, when I do a will for somebody, I don't follow up with them. I don't stay in touch with them. When they're ready to revise it, they contact me and we revisit it. If I had the staff and I was smart enough, what I would do is every 5 years I'd have ticklers and I'd contact people and say, let's review your will and and all that kind of stuff. And some practitioners do that. But all I can say is if you don't have an attorney that does that, then really it's up to you to have your will reviewed and looked at every now and then in a quick phone call with me. For example, if I did a will with you, it's digital. I could pull it up, and in 30 seconds I could say, no, you're good, everything's fine. Or, yeah, boy, we better relook at that. And I have had that happen lots, unfortunately, a few times where folks, back, I don't know how long ago, 10, 15 years ago, you could only die with $600,000 per person before federal inheritance taxes kicked in. So, and now it's a whole new ballgame, and we are going to talk about those limits and how much you can pass away with before the federal government, it comes into play with inheritance taxes. But I've got some wills out there that we did credit shelter trust for $600, and we divided the assets between husband and wife and all that stuff is obsolete. So if you have a will that was done over 5 years ago, relook at it and call the lawyer that helped you or call me, and we'll look at it and see if it even fits what you need anymore. But, I know that's a lame excuse, but unfortunately that's kind of the way it is. Because most people don't pay attention to the federal inheritance limit and the gift tax laws and all that kind of stuff. But I do think that it's reasonable, to my defense maybe a little bit, it's reasonable to put a little bit of burden on a client. If your will's over 4 or 5 years old, you need to be looking at it. Because a lot of things change in 5 years. But that's typically the benchmark we use is every 5 years. Or a life event, a change in a life event. We're going to start going over some of these terms here. Any other questions or comments or clarifications that are needed, that kind of thing? And once again, remember, these things I'm saying they're general principles, they're general rules, and there are exceptions to every single rule. So if it looks like I'm talking down one particular form of ownership, or if I'm say that doesn't mean it's perfectly fine or better to do the other route, because everything is fact specific. That's why I think I mentioned I'm not a big fan of the online will preparation services. I actually paid the money and did a will through LegalZoom myself just to see what the process looked like and to see how sophisticated it was. And it was very good. It was very good, but, I understood the questions they were asking me. And even if they make it in layman's terms the best they can, there's still do I take a right turn or a left turn? And you're not really sure, So I don't like those type of programs. And then the problem is if you get it done right and then you print it out, did you execute it properly? I'm working right now on a situation where, I don't think I've told you about this one, where this fella, I guess he's mid-60s, something like that. He had 2 brothers. One's passed away, so he has another brother. The one that passed away has a son. Everybody's a little bit disjointed. They get along okay, but not great. But my client lived in a house next to his mom. And then when she got really ill, he moved over into the house and lived with her after he retired from Metro government, and lived with her for 10 years probably and helped take care of her. Took her to every doctor's visit, made sure she had her medication. She could not have lived in that house by herself without him. He even moved out of the house that his spouse lived in, and she understood so he could honor and take care of his mother like he did. And so, but she did a will, kind of one of these self-help wills, and it wasn't executed properly. And she had gone to all her bank accounts and divvied all the money up in the bank accounts just perfectly. Except that house was supposed to go to my client, we'll call him Joe, as a thank you for living with me for 10 years away from your spouse to take care of me. And whether that's healthy or not, that's what happened. And she left the house to him in her will. And the will's not going to be admitted to probate. So it just was defective, and the judge is not going to admit it to probate. So it's not a valid will. So that means then she died without a will, so everything is split equally between her children. The other 2 siblings, they already got their inheritance through joint bank accounts. So they each got a couple $100,000. His couple $100,000 was the value of this house. So now he's going to get third of $200,000. He's going to get $65,000, and each of them are going to end up with $265,000 because she didn't have the will done correctly and it wasn't done right, and we just can't get it admitted to probate. Tried, we just can't.
So the judge doesn't take her intentions into account?
That's a really good question. The law does favor the testator's intent. And judges, and I have seen in particular the Davidson County probate judge sometimes really stretch to have the intent. But you can't make something that's defective legal. If it wasn't, I think I told you before, and we'll circle back around when we get to wills, but if the will is typed out, it has to be signed in the presence of two witnesses that have to watch the person sign the will, and they have to watch, each witness has to watch each other witness the will. If that doesn't happen, then it's not admissible. It's not valid. And one of the witnesses is dead, so I can't get any testimony from them. And the one witness that has survived, I asked him to sign an affidavit that he truly witnessed her sign it and witnessed the other witness sign it. And he said, I just can't remember. It's so long ago. I can't remember if I did or not. Well, actually what it is he's the spouse of he was the spouse early in her life, and they stayed, the lady who died, he was her ex-husband, but they have a common child, and that child is going to get more money with that will not being admitted to probate. So he conveniently doesn't remember and won't sign an affidavit. So, happens all the time. I had a case in California here, but it was a similar situation, but I made a good faith argument, I think, and got it in front of the judge. And but one of the kind of the long lost heir who would have gotten everything if the will was not admitted to probate lived in California and hadn't seen this lady. It's like a great aunt or something like that. Didn't know her, hadn't seen her in forever. But this person stood to get the whole thing if the will was not admitted to probate. So I gave the judge the facts. We gave as much testimony, and I can't remember, it's been 10 or 20 years. And we served the person in California. All they had to do was just file. If they would have just filed anything in the probate court, the judge would have never admitted that will. But they got served. I had proof that I served them. We waited X amount of days. They didn't show up. Judge admitted the will to probate and avoided that tragic situation. And I think she had left it to some neighbors in the neighborhood that took care of her for her last 20 years of her life, checked on her, gave her food, cut her grass, cleaned her house, which was the right result. And the judge did. I mean, I walked out of there thinking, oh, my word. And then, that will could have been contested, but it wasn't. And maybe kudos to the person in California that just said, hey, I shouldn't do that because I'm not entitled to it. Maybe, I don't know. So that's a long way to answer your question. But intention, yes, does come into play, but you can't make something legal when it's not. Anybody that's in here that has a comment that, or something that's their experience has been different, though, I'm willing to hear it. Or any of our attorneys here that have a difference of opinion, I'm open for their suggestions or comments as well. So if not, we're going to move on to this handout. Administration. So we talked a little bit about that. I'm not going to go over every term. I have some terms circled, and those are the ones that I think are relevant to our discussion about wills and trust here. So let's take about 10 minutes and go over the ones that I highlighted. Administration, like we talked about, is court-supervised distribution of estate during the probate of a will, or an administration also is the same process without a will. So with a will, it's called testate. Without a will, it's called intestate. Sometimes people loosely refer to administration as to what happens with the trust when the owner of the trust passes away. Did we have any more? Or did we hand them all out? Next, administrator. So an administrator, if there's a will, you go to court, and you have to go to court if you're going to have a will and you want the will to speak and the terms of the will to be distributed, to be carried out. The will has to be admitted to probate. The judge has to approve through testimony or through self-proving affidavits attached to the will that this is in fact this person's last will and testament. It was done legally, then it becomes an official document. The personal representative who is charged with carrying out the terms of the will is generically called a personal representative. A personal representative is a generic umbrella term. If there's a will, the person is called an executor if it's a male. It's an executrix if it's a female. If there's an administration, there's a personal representative, and there's no will, that person is an administrator or an administratrix. And then there's even sub-designations of that depending on if a person replaced another administrator, but CT this and all that kind of stuff. Latin abbreviations that come into play. The next one, flip over to the next page on top. Beneficiary. Beneficiary is a broad term. A person who receives something from a will, a trust, or other legal contract, such as a life insurance policy or a IRA, those are generically termed beneficiaries. In the margin there, devizee, that specifically means somebody that is bequeathed real estate in a will. That's a devizee. If you get real estate through an administration, the person died without a will, you're not a devizee. That's only for people that acquire real estate through a will that's admitted to probate. That person is just a beneficiary or an heir at law if that person gained that property through administration without a will. Bequest or devise. A bequest or a devise is a gift in a will or trust. Gifts meaning I bequeath this to you. I direct that this be paid to this person. Gift not in the form of what we generically think of as a gift, but a distribution through an administration. They can be specific or residuary. So let me talk about that just a little bit. When you have a will, you typically you say in the will, I want all my debts to be paid. That's typically what you start off with. And then, if you have any specific things, personal property items, which will be defined here in a little while, personal property, things that you can touch and feel, that's tangible personal property. Then there's intangible personal property, bank accounts, things like that. If it's not real estate, it's personal property. There's only two categories, real estate or personal property. And then personal property is either tangible, which means you can touch it, and intangible, which means you can't, okay? But a bequest is where you get something, an inheritance through a will. That's a bequest. Or a devise is where you get real estate through a will. But you have the specific bequest. So we typically say, okay, I pay all my bills, and then I want to leave my dad's gun to my grandson Johnny because he always loved that gun and he always wanted it. And so we'll do that. Or we'll talk about family heirlooms that a granddaughter or a daughter particularly liked, things like that. So we do that, and that's a good thing. More and more, we're moving away from having specific bequests in the will itself to a reference of a memorandum that you prepare and attach to your will that's in your handwriting that you can change over time. So if you want to mark it up and swap things out, you can, and typically the court will approve that if it is in your handwriting and witnesses. If it come to shove and some beneficiaries dispute the validity of that, you can admit that to court as a holographic or a handwritten part of the will. if you can verify the person's handwriting. So we typically don't do a lot of bequests in a will because those are the kind of things that can change. I got rid of the gun. I sold that car. I already gave that teacup set to my daughter. I already gave her my wedding ring. It was her granddaughter's wedding ring now, that kind of stuff. So we typically don't have a lot of specific bequests and wills now, although that's traditionally the way you do it. Then after that, you then, very generically speaking, you have what's called the residuary. And the residuary is after you pay the expenses, and if there's any federal inheritance taxes, which is very rare, then everything that's left over is the residuary. And you say, I divide my residue between my 3 children, kind of thing. And I had a situation where a lady had a will, and her maid, her housekeeper, did it for her on the computer. And she actually did get it executed properly. It was witnessed. There were self-proving affidavits. But the maid just thought, well, this residuary clause is just not necessary because they listed every single asset the lady owned. This bank account at Merrill Lynch, this bank account at Regions, this bank, and what happens 20 years later? Anybody guess? What happens 20 years? They changed. Those bank accounts don't exist anymore. Those 2 bank accounts went into this bank account, and it gets all confusing. But that's why you don't do it that way. You then say, I'm going to estimate my estate's going to be worth X, and I want it to be divided in these percentages, or I want X amount to go to each child, for example. Then it doesn't matter what happens to those accounts. It's what's left after everything is the specific bequest and the taxes are paid and all that. And so that will, what happened on that? That might have been the one where the person in California, anyway, it was a really, really squirrely result, but it heightened, in my mind, one of the reasons why I don't like people self-preparing through the internet wills, because you don't appreciate residuary. It just seems so innocuous. I've already given everything away, this bank account and all that, but it's just more complicated than that. Next, bypass trust or credit shelter trust. We don't see a lot of those anymore. That's when they were used a whole lot. They may still be used some, but they don't in my practice, because that was when the federal limits were $600,000 per person. So if you had assets over $600,000, we would put money in trust for the spouse and all that kind of stuff. And those are called credit shelter trusts. And we just don't need to do that anymore because each person, I can't remember the number, 12 or 13 or 14 million per person now before there's any federal inheritance taxes. So they're kind of out of vogue now. Certificate of trust, that is if you do have a trust and while you're living, you have a living trust and you need to show the car dealership, hey, I want you to title my car in the name of my trust. They'll say, well, I want to see your trust. I need to see your trust. Well, you don't want to bring your trust. So you have a certificate of trust that is a legally recognized document that has all of the term. I'm the grantor, I'm the trustee, this is the trustor, and it's a 1-page deal, and then they're allowed to use that, so you don't have to bring your 50-page trust or 20-page trust to. Next page, about halfway down. Oh yeah, I skipped that.
Different from what you were describing, the handwritten?
That is different. A codicil, and I probably should have circled that. I went through and kind of circled the ones I wanted to talk about. A codicil is an amendment to a will that's done at a later date after the initial will was done. Now, the handwritten memorandum that you come back and kind of change, maybe it could be considered that, but typically when we think of a codicil, we think of a more formal changing of the will itself through the same formal process as you did the first go-around. But there could be some bleed over there. Yeah. Next page, death tax. We'll see that on estate tax. Devise, we talked about that. Devisee, that's the person that gets the devise. Remember, that's real estate that you get through a will. Disclaim is where if a person inherits property in a will, they can refuse to accept that bequest, and it has to be done within a certain period of time from the person's date of death. But that's a really good tool, because sometimes a person says, I don't need it, I don't want it, and so they refuse it, and throws that money back into the kitty, if you will. So it's a good thing. And I've had several disclaimers where people that inherited property, they just don't think it's fair, they don't need it, so they throw it back into the estate for the rest of the folks to split. Okay, next page, disinherit. Disinherit is when this definition here, I got this from a site that I found. I didn't create this. This is a little different from us. In Tennessee, there is no presumption if you die that your children or anybody are entitled to your property. We loosely use the term, I'm going to disinherit my child for whatever reason. But what you're really doing is just refusing to list them as a beneficiary under your will. We don't have any kind of presumption of, lineage and bloodlines and all that, although that is typically what people do. We spend a lot of time talking, I do in particular, I spend a lot of time talking with folks that I meet with about inheritances, and certainly not telling them what to do, but getting to think a little bit about who they're leaving their assets to, why, and is it fair to the others? Do you want to reward this behavior? What will happen to your money if you leave it to this person when you're disappointed in their lifestyle or the decisions they're making or whatever? And then I leave it in them, and then I say, let's talk later. Let's shut down the meeting now, give you some time to think, and when you're ready, let's talk again. And about half the time, they want to just continue on with it, even Stephen, if you will. But then about half the time, I'm thinking, I've thought about it, prayed about it, and I want to do something different. And from a biblical perspective, Carl and I have talked about this a lot, and he's done a lot of research, and at one point, I think we will probably talk about this, is about using the Bible and biblical principles to kind of help us as a guide as to who our beneficiaries are, and as to whether we are doing the right thing by leaving our assets to our children or whatever, regardless of their decisions or what they're doing with their lives, etc. Distribution is, back to disinherit, I don't want to leave you with the impression that if a person passes away with a will and they've chosen not to leave something to a child, that child is not an interested party that couldn't come to the table into the courtroom and say, look, I think there was shenanigans going on when Mom executed this will with Joe, my brother Joe. She didn't want everything to go to him. I spent more time with her than he did. And there was undue influence and all that. So the law is very, very good, and the local rules are very good of court, because if you have a will that's admitted to probate, that you're submitting to the probate court for consideration, you have to notify all of the parties that would inherit if there was no will, which just makes sense, right? And they have a chance to come to the table and let their voice be heard. And so they don't even have to officially file a will contest. They could literally show up at the hearing, because I have to notify every beneficiary. We're probating the will. I'm notifying you it's going to be on this date. And if they come up, raise their hand and walk up to the podium, tell the judge this is not this, then he's going to hear it, or she's going to hear it, and it's not going to be quite as easy. There's going to have to be some serious proof given and those kind of things. So the law does try to protect family members from unscrupulous siblings or unscrupulous people that might have undue influence on folks that do wills. And unfortunately, I see that a decent amount too. And that's one of the things I have to deal with when people come meet with me and one child brings the person and the other children aren't there. If everything is not even, then I have to really be careful. And a lot of times, then I'll always have some time with that person alone. Anyway, so it's a very solemn process that we go through to make sure all that's done right. Coming on down, estate, that's the total assets and debts of a person at their death. Estate planning is kind of what we're talking about. Estate tax or death tax. In Tennessee now, we have no inheritance taxes at the state level. That was done away with maybe 5, 6, 7 years ago. So no Tennessee inheritance taxes. But there is federal inheritance taxes, but they kick in, I think, at $14 million is what it is. 12.06 increases each year by inflation. I think, what is it this year? Because I think in 22 it went up again. Okay. So there you go. It's 12,060,000. That's right. So what do you want to talk about that, or do you want me real quick?
Legislation has to be passed to raise it.
Yeah, and there's legislation right now that's potentially monkeying with that as well. And all we can do is talk in terms of, where we are now. But when you talk with somebody, if you get an estate that's several $1 million, then if it's, in north of 20, 30, 40, 50, 100 million, something like that, which we see, I refer them on to somebody else that's a specialist in tax planning and that kind of thing. But if it's most mortals like the rest of us, we're good, even with the sunsetting and all that. But that's the reason why we, every 5 years, think you should relook at things and contact the person that did it for you. But what he was referring to is the 12,060,000, let's say it stays that way, that's your total amount during your life and your death. So if you gave $1 million gift to one of your children, then you only have 11,060,000 left when you die to use up. I don't find that being a problem in my practice, but in some of the practices with really high net worth individuals, it probably is. Yeah. But most of the time when you get into that, you're getting real sophisticated with family limited partnerships and LLCs and all kinds of fancy planning and that kind of thing. Let's see, what was the last thing we talked about? Gross estate. Let's keep going. On the next page, flip over. Heir at law is a beneficiary that inherits through probate administration without a will being admitted to probate. It's no will. Holographic will is a handwritten will. We're going to talk about that. Next page, inter vivos means during life or between the living. So we'll talk about inter vivos trust versus testamentary trust. Inter vivos trust is a trust that's set up while you're alive. A testamentary trust is a trust that's set up when you die in your will. Interest of a beneficiary is self-explanatory. Intestacy versus intestate, that's did the person die with the will or without? Irrevocable trust is a trust that is intended to not be changed or terminated once it's created. I do not wade into those waters too much, so if that's something you're really wanting to do, then I refer people like that on, because it's a whole nother animal from what I deal with day in, day out. Issue is a legal term that we use generically for our heirs, our blood, our lineage. We use that term issue in a generic way. Joint ownership, joint tenancy, we've talked about that. Living trust is what we typically think of as when we talk about trust. Well, hey, I want a trust. While I live, I don't want a will, I want a trust. That's what you're talking about. You're talking about a living trust because it's set up while you're living and it's effective while you're alive. Next page, minor, that's somebody that's below the age of 18. And the reason why I'm cherry picking these terms, I think they're the ones that tie most into our discussion of wills and trusts, which will obviously be 2 weeks from today. The net estate is the value of an estate after all debts have been paid. A no contest clause is I forgot what the Latin term is. Does anybody remember what the official term for a no contest? You remember what it's called? No, a clause in a will that says if you challenge the will, you're disinherited. I forgot what it is. But they're enforceable in Tennessee. Some states they're not. But you can put a clause in your will that says if XYZ child or XYZ beneficiary challenges and loses, they're out. It's a pretty good tool. Non-cupative, that's a verbal will, very limited application. Has to be on a deathbed. It's very limited in terms of the amount of money you can process or you can, administer. Payable on death, we've talked about that. Per capita versus per stirpes, that's very important. Per capita is when you leave assets to let's say 5 individuals. And if you leave it to them per capita, if one of them passes away, then it's divided between 4. If 2 of them pass away, then the whole amount is divided between the 3. That's per capita. Per stirpes means by representation. So if you have 5 children, you're leaving everything in fifths. If son number 1 passes away and it's per stirpes, then his inheritance goes to his lineage. Not his spouse, but his bloodline. And you think about that. So when you do a will, your own will, which sometimes is fine, or online, if you don't know those terms, think how that could make a difference. Well, of course I wanted number 1 son Johnny's interest to go to his children if he predeceases me. But if you thought, well, per capita sounded better, then his children are disinherited, and you didn't intend for that to happen. Personal property, we talked about that. Next page, personal representative, we talked about that. Pour-over will. A pour-over will is a will that is done in conjunction with the living trust. When we get to the discussion about assets, if we want to do the will route versus a living trust route, even if you have a living trust, you have to do a pour-over will. Because if, when you pass away, you had an asset that was not titled in the trust when you died, you got to have a will that pours it over into the trust so it flows through the trust. You still have to probate it, but at least that asset is going to be dictated through the terms of the trust. So that's what a pour-over will does. Very important. Principal or corpus is, we'll talk about that some more. Probate, common versus solemn form. So that's pretty interesting, and it's a good point of discussion. If somebody comes to me and it's a good solid will, there's no reason why we can't admit it, but maybe a child is disinherited or a brother is disinherited or something like that who thought he was going to get this or that. If you probate it in common form, then I think it's a year for anybody that's an interested party to file a will contest. If you probate it in solemn form, then I think it's 30 days, but you can't go to court on a solemn will probate without serving every interested party as if they're being sued. So it's a big deal. Everybody gets served like a lawsuit almost. It's not exactly like that, but they get served so they know it's a big deal. But if they don't come to court and the court admits it in solemn form, then there's no will contest. It's over. You had your chance. You were warned. You didn't follow through or whatever. So I have probated 1 will in solemn form in my career. And I've done hundreds in common form. And I've never been involved in a will contest yet. My partner has been in a couple, but I haven't yet. Probate estate is the part of your estate that goes through probate. The gross estate is everything you die, including assets that are jointly owned or the PODs. All of that is figured in for inheritance tax purposes for the $12 million. But probate is just the portion that is administered through the probate process. So if you have a $10 million estate and $5 million of it is payable to your family through joint accounts or IRAs or 401ks, and only $5 million flows through the will, then $5 million is the probate estate. The $10 million was the gross estate for calculation of federal inheritance tax purposes. Probate fees are fees generally for the attorneys and for the court costs. And probate fees can vary wildly from one case to the other. The general run of each practice, each firm's a little different, but probating wills is not complicated, especially if it's done nicely and it's prepared and people are ready to go and all that. You know, $2,000 or $3,000 maybe in attorney's fees, but if it's a mess, you know, it could be $100,000 in terms of attorney's fees if it takes 10 years and, you know, that kind of thing. But most of mine are on the very low side because they're very, very simple generally. Real estate, we talked about that. Residuary estate, we talked about that. Revocable trust. Anytime you do a living trust like we talked about, you can revoke it while you're alive and competent. If you do a living trust and you're still alive but you don't have mental capacity, then you can't revoke it. It becomes irrevocable at that point. Settle an estate is administering the probate or the trust. Spendthrift provision is a provision, a clause in a will where you're protecting the beneficiary from creditors. So it's a clause that you put in there, so if a child is going to inherit money and they may have financial problems, you have a clause in there that protects that asset from getting absorbed by the creditors. Spousal share, we'll talk a little bit more about that. That is important. Successor trustee is the second in line in a trust to be the point person. Tenancy by the entirety, that's owning real estate with a spouse. And boy, that's changed. Who would have ever thought? I never would have thought in my life that I would be doing real estate transactions. One of my employees today, I walked by her office, she said, boy, that was uncomfortable. I said, how so? She said, well, I was talking to this person, let's say her name's Lynn. And I said, well, what's your husband's name? Because Lynn was buying property with her spouse. She said, Lynn, what's your husband's name? So we can put that on the, oh, well, my wife is Judy. And, you know, we see that a decent amount now. Tenants in common is ownership of real estate when there's not a survivorship interest type thing. Testamentary is when it's through death as opposed to living, which is during life. Testator is a person who does a will. The next page, we talked about taught and trust and transfer on death, and we're going to talk about trust some more. And that's all I circled. But if you guys want to look at this and, you know, highlight or say, hey, I'm interested in knowing a little bit more about that, we can talk about that. But I'm already prepared for next week, and I've got 3 pages of wills and revocable trusts and what's good about wills, what's bad about wills, what's good about trust, living trust, and what's bad about them, and how we can compare so you can make the decision which one's best for you.
I don't see on here the term DAF. Is that something for this discussion or something?
DAF?
Yeah.
What does that stand for?
I'm not sure what it is, but it's a vehicle that you use to distribute money for charitable purposes.
Does anybody know what a DAF is?
Donor advisory fund.
Okay.
You can put money in a big tax-free at the moment donated, and then you can designate it to go to a charity. It has to be a 501c3 charity
Okay.
at some future date. It's a great tax planning strategy for people to have to put it in this.
Yeah, there's a whole world of charitable trust and charitable lead trust, charitable remainder trust. There's all kinds of charitable trusts and charitable things like that, which is outside of my expertise. My firm does do that. My partner who's chairman of the board at Agape and, you know, is very familiar with all that stuff. I don't. I stay busy enough doing kind of the regular run-of-the-mill stuff. Anything else? We're over time, but next week we'll answer questions, and then next 2 weeks, right? Your next week. Then we'll talk about wills and trusts, and then I have, I think, 2 more after that too. So, thank y'all.